Steve, and it's so lovely to see you all, albeit virtually. Hopefully you can hear and see me okay. It's breaking up a little bit on my end, but I'll just press on. So Loielo and Giles is a judgment of Justice Ganane in the Supreme Court of Victoria that the curfew imposed from 9 p.m. to 5 a.m. in Melbourne during our stage 4 lockdown was valid. It's certainly a COVID case, but only a small c constitutional case in the sense that it was a challenge to validity of laws, a historical exercise of executive power in Victoria. I was thrilled to move to Melbourne for the first curfew of its kind, and an example of proportionality reasoning by the courts, but in the absence of strict constitutional arguments, it's without the structured proportionality reasoning that's found favour with the High Court in implied freedom cases recently. I, for one, spent most of lockdown waiting for a judgment on some of these questions, not necessarily for any political reasons or views on COVID, but that there were many varied emergency powers being exercised in unprecedented ways that I had been advising on and musing about. I'm not sure my partner was thrilled that he had 3 months of lockdown to listen to me drone on about constraints on executive power, but I really did find it phenomenal standing in our backyard watching helicopters going overhead to track people on the roads, thinking if I take one step forward out of my front gate, then I'm committing an offence. Donning his now trademark North Face jacket, the Premier joked in one of his daily press conferences that the effect of the curfew was a prohibition on going for a jog in the dead of the night. The plaintiff in this case didn't agree. Miss Loielo was more than just a bored Karen from Brighton. Justice Ganane held she had standing to bring the challenge because she owned a restaurant on the peninsula and she could show significantly reduced turnover following the imposition of the curfew direction. She wasn't cross-examined to determine the link between the financial loss that she sustained and its link to the curfew, but the judge could see no reason not to conclude that she did suffer some financial loss. The curfew direction was made by Associate Professor Giles as an officer authorised by the Chief Health Officer under Victoria's Public Health and Wellbeing Act. The powers exercised by her were enlivened on the declaration of a state of emergency by reason of the risk to human health posed by COVID-19. She held the position of Deputy Public Health Commander, but it wasn't clear to the judge on the evidence what that position meant, nor why the Chief Health Officer wasn't exercising these powers himself. No chart showing the organisational structure of the department could be produced that explained it. 381 other people were authorised officers under that Act, and Giles had been authorised 2 days prior to the curfew direction to fill in for another who was going on leave. The imposition of the curfew direction was the exercise of a discretion. The question of whether the curfew was reasonably necessary to eliminate or reduce a serious risk to public health was a subjective jurisdictional fact. The evident message when reading this judgment is that Professor Giles was really a star witness, and her detailed testimony of all relevant considerations in making the direction was supported by emails and other documentary evidence that really just seems like a public lawyer's dream. But despite Giles's persuasive evidence, Justice Ganane did remark in some short but important obiter, Parliament may wish to reconsider who should exercise these emergency powers and whether their exercise should be required to take into account matters such as the social and economic consequences of their exercise. While in the judgment it feels like that paragraph somewhat has some crickets coming after it, given the same powers were exercised to put Victoria's entire economy onto pilot light for nearly 3 months, and at the risk of sounding too existential, it really is quite a lot to think about. In the case of the curfew, Miss Loielo's argument was that this direction went one step too far. There were 3 bases to the challenge. First, in making the curfew direction, Giles acted at the direction or behest of the... It was obvious, she said, because the Premier announced the curfew at his daily COVID presser in the morning and the direction was signed just after 10 p.m. that night. Second, the curfew direction was unreasonable, illogical and irrational in the legal sense. And third, the direction violated her rights under the Victorian Charter. There was no shortage of evidence from the Premier's daily press conferences, which was used by Ms Loielo to suggest that the curfew was imposed primarily to aid law enforcement rather than to eliminate the public health risk. The judge noted that Giles was in an awkward position and that she was being asked to make an independent decision after the Premier had announced what in effect was a decision on the same issue. But the judge was ultimately satisfied that Giles came to an independent decision and did not just follow and adopt the Premier's announcement. Amongst a number of factors, she understood that the power was hers to exercise. Her evidence was that having people at home for 8 or 9 hours out of 24 had the potential to reduce the aggregate risk from different households mixing. No single measure would be effective by itself, as interventions work in conjunction to reduce the risk of transmission. There were 99 cases with an unknown source in the previous 14 days, which meant Victoria was at a pivotal turning point in the trajectory of the virus. And in her opinion, 3 things were really important to control the risk of transmission: contact tracing, reduction in movement and interaction of people, and adequate testing. It was difficult for Ms Loielo to demonstrate that the decision was outside the scope or purpose of the statute in the circumstances where emergency powers were being exercised based on the authorised officer's decision of what was necessary. Justice Ganane held that the curfew was proportionate to the purpose it sought to achieve. Because it was in the exercise of emergency powers under the Public Health and Wellbeing Act, its introduction did not occur in an arbitrary manner. I'll end this presentation here, and I wish I could have made more jokes about the exercise of these powers, but I found it so comforting to read Professor Giles's evidence. I still don't think I'll ever take it for granted going for a jog in the dead of the night.